Recently, it came to my attention that the Department of Justice has asked several United States attorneys from around the country to resign their positions, some by the end of this month, prior to the end of their terms, and not based on any allegation of misconduct. In other words, they are forced resignations. I've also heard that the the Attorney General plans to appoint interim replacements and potentially avoid Senate confirmation by leaving an interim U.S. attorney in place for the remainder of the Bush administration. Now, how does this all happen? The department sought and essentially was given new authority under a little-known provision in the Patriot Act to appoint interim appointments who are not subject to Senate confirmation and who could remain in place for the remainder of the Bush administration. Now, to date, I know of 7 U.S. attorneys forced to resign without cause, without any allegations of misconduct. These include 2 from my home state, San Diego and San Francisco, as well as U.S. attorneys from New Mexico, Nevada, Arkansas, Texas, Washington, and Arizona. In California, press reports indicate that Carol Lam, U.S. Attorney for San Diego, has been asked to leave her position, as has Kevin Ryan of San Francisco. The public response has been shock. Peter Nunez, who served as the San Diego United States Attorney from 1982 to 88, has said, quote, "This is like nothing I've ever seen in my 35-plus years." He went on to say that while the President has the authority to fire a U.S. attorney for any reason, it is extremely rare unless there's an allegation of misconduct. Now, to my knowledge, there are no allegations of misconduct having to do with Carol Lam. She is a distinguished former judge. Rather, the only explanation I've seen are concerns that were expressed about prioritizing public corruption cases over smuggling and gun cases. Now, the most well-known case involves a U.S. attorney in Arkansas. Senators Pryor and Lincoln have raised significant concerns about how Bud Cummins was asked to resign, and in his place, the administration appointed their top lawyer in charge of political opposition research, Tim Griffin. I have been told Mr. Griffin is quite young, 37, and Senators Pryor and Lincoln have expressed concerns about press reports that have indicated Mr. Griffin may recently have been a political operative for the RNC. While the administration has confirmed that 5 to 10 U.S. attorneys are being asked to leave, I have not been given specific details about why these individuals are asked to leave. Around the country, though, U.S. attorneys are bringing many of the most important and complex cases being prosecuted. They are responsible for taking the lead on public corruption cases and many of the anti-terrorist efforts across the country. As a matter of fact, we just had the head of the FBI, Bob Mueller, come before the Judiciary Committee in our oversight hearing and tell us how they have dropped the priority of violent crime prosecution and instead are taking up public corruption cases. Ergo, it only follows that the U.S. attorneys would be prosecuting public corruption cases. As a matter of fact, the rumor has it, and this is only rumor, that U.S. Attorney Lam, who carried out the prosecution of the Duke Cunningham case, has other cases pending whereby, by rumor, members of Congress have been subpoenaed. I've also been told that this really interrupts the flow of the prosecution of this case, of these cases, to have the present U.S. attorney be forced to resign by the end of this month. Now, United States attorneys play a vital role in combating traditional crimes like narcotics trafficking, bank robbery, guns, violence, environmental crimes, civil rights, and fraud, as well as taking the lead on prosecuting computer hacking, internet fraud, and intellectual property theft, accounting and securities fraud, and computer chip fraud. Now, how did all of this happen? This is an interesting story. Apparently, when Congress reauthorized the Patriot Act last year, a provision was included that modified the statute that determines how long interim appointments are made. The Patriot Act changed the law to allow interim appointments to serve indefinitely rather than for a limited 120 days. Now, prior to the Patriot Act and the 1986 law, when a vacancy arose, the court nominated an interim U.S. attorney until the Senate confirmed a presidential nominee. The Patriot Act in 2006 removed the 120-day limit on that appointment. So now, according to the Patriot Act, the Attorney General can nominate someone who goes in without any confirmation hearing by this body and serves as U.S. Attorney for the remainder of the President's term in office. This is a way, simply stated, of avoiding a Senate confirmation of a United States Attorney. The rationale to give the authority to the court has been that since district court judges are also subject to Senate confirmation and are not political positions, there is greater likelihood that their choice of who should serve as an interim U.S. attorney would be chosen based on merit and not manipulated for political reasons. To me, this makes good sense. Finally, by having the district court make the appointments and not the Attorney General, the process provides an incentive for the administration to move quickly to appoint a replacement and to work in cooperation with the Senate to get the best qualified candidate confirmed. I strongly believe that we should return this power to district courts to appoint interim U.S. attorneys. That's why last week, Senator Leahy, the chairman-to-be of Judiciary, Senator from Arkansas Pryor, and I filed a bill that would do just that. Our bill simply restores the statute to what it once was and gives the authority to appoint interim U.S. attorneys back to the district court where the vacancy arises.